Okay. What's the word?
Defense would like to approach for bond.
Okay.
The state would be opposed.
And so, Your Honor, I wanted to approach on bond, and I did speak to my client and let them know the process and what could happen in asking for the bond. My client informed me that while he's not working, he is on SSI, married with 3 children. They were actually on a road trip headed to visit some family in North Carolina. When they stopped, he was subsequently arrested on some other charge, another PCS charge, I believe. And it was dismissed here. It was dismissed because it was actually someone else's drugs or whatever the case may be, but I just wanted to be open with the court and let you know that there was that case. It was dismissed fairly quickly. And then, we find out about the warrant out of California now that I guess was released on 5/19. He did let me know he's in SSI, wife does work. Has an 18-year-old, an 18-month-old, and a 9-year-old child. They are headed back to California. This obviously put a block on their road trip. But he does say.
Why are you opposed? Any particular reason?
Judge, the defendant has a rap sheet of 23 pages, including at least 4 from my browsing of probation violations. He has another FTA. The warrant right now is out for an FTA in California. We just cannot trust him to go back to where he's.
Does he have any other fugitive cases?
He had a previous fugitive case in Addison that was dismissed.
How long ago? Here in Harris County?
Yes, that one was filed.
He had a prior fugitive case. It's not going to happen.
And Your Honor,
Sorry.
What I will say is it looks like it was dismissed. I think it may be something where he actually did go turn himself in.
I don't know. We'd have to look, but maybe the demanding jurisdiction didn't just come pick him up and Harris County released him because it's really expensive to pick someone up. So a lot of times they just won't.
And I understand that, Your Honor. My biggest thing is the SSI is, that's the bulk of the pay for him and the family. That's our wife and children are getting back and forth.
If I were to set him a bond, it's going to be probably 5 digits just because of his extensive history and because he's had a prior FTA here in Harris County before. So there's going to be significant resources so that we know and so that he knows that we mean business if we set him a bond, because I'm not going to give him a low bond on a fugitive case where he's got a rap sheet that long and a prior fugitive case.
I understand that if you were to go 5 digits, Judge, I would ask for a $10,000 bond. I do think between him and his wife, he has the ability to make it. Wife and kids are waiting to be able to drive back to California. He's let me know that he will turn himself in. I do understand a rap sheet and having issues with that, but knowing that he has had probations and other things going on, that tells me, even if he's not doing the best or the greatest, we know drugs can be an issue, but that at least tells me that he is somewhat handling his business and doing his best to return to courts.
If you want, I'll set you a $10,000 bond. Has he waived or has he refused?
He's currently refused.
He's refused. So, he's not earning any time anyways. If you want, I can set you a $10,000 bond. Just, I don't know how much they're going to require. Probably not just 10%. They're probably going to want more than that. So just let him know and
absolutely
we'll go from there.
And then, Judge, not on the fugitive case, I did just want to let you know that Miss Green's brother is here in court. I didn't know he was here earlier, but he did appear because he wanted to inform the court that he pulled up to the pretrial to the Intoxilog places business because of the issues with the alcohol and things of that nature. And it was blowing high for him and his mom too. And they were surprised to hear that Miss Green was in jail. They admitted to him that the machine was messed up. And he appeared to come and inform the court. And I would just like the court to take that into consideration and and hopefully at least come down to $1,500
No,
bond.
no.
She has to enroll in
Mr. Burnett,
classes for this
I've
semester.
got a lot of stuff to do. I'm not going to get into this again. I've reduced it to 3,000. That's it, 3,003 or whatever it may be. I'm not going to go any lower.
She has to enroll for classes.
Not gonna do it. I'm sure that they can find the resources. I'm sorry. It's just,
Later this week, if I bring somebody.
no,
from that
I'm not
company
gonna
in,
commit.
consider it.
No, just please.
I'm sorry, I have a really hard time hearing.
She
that.
has
We're-
3 bond violations. I'm not gonna go lower than $3,000. I'm not gonna get into this with you right now, man. Really. You know what? Do you really want me to hold you in contempt, Mr. Burnett, for being disrespectful?
That's what we're gonna hold me in contempt for being disrespectful.
You're calling me insane. You said that's insane.
That's not calling you insane, Judge, but I do think that.
It's
that-
completely
I do-
disrespectful and you're getting out of hand.
I think it's out of hand to jail people when we know these machines are faulty, Judge, and we know it. We know that that's not accurate. We know that it's impossible for that BAC to jump at that within 45 minutes.
Serenity now. Serenity now. I'm not going to get into this discussion. Are you ready?
Yes, thank you, Judge.
Thank you. Good morning, Ms. Treadwell. How's jail? This is what you need to think about. Every time in your mind, you're out in the free world and you start thinking of some kind of shenanigans. If I do this, could it land me in jail? Because the problem is when you go, ain't no one gonna bond you out. So you are stuck like Chuck when you go to jail. And I don't know if it stems to the fact that you have nothing going on, you have no job. I don't know if you have an education, but when people have too much time on their hands, they become self-destructive. You need something to do in this life, whether it's working, whether it's going to school full-time. But now, as you can see with the history that you have, the past 2 years have not been very good. You understand? Both the state and your defense lawyer have worked out a screaming deal for you where, and us are reluctant, but we will accept if you make and you get a JOB, a full-time, legitimate 9-to-5 tax-paying job, not something where I'm doing home health care, not something where I'm doing hair, not something where I'm making arts and crafts, a full-time 9-to-5 job. And I am now amending your conditions of your probation to give you 1 month to get a full-time job. And if you do this, the probation will be extended and they will dismiss the theft case for you. But I'm telling you, every time you start to play games, another motion could possibly be filed. And I'm telling you now that I am sick of giving PR bonds. Do you understand? The literal only thing you have to do is stay clean and get a job. You will be back here in 30 days, and I want legitimate proof that you have a job on letterhead from a company so that they can call and verify that you have a job. If you bring something on a bar napkin, it may not go very well between us. Do you understand? Your bond is right now at around nearly $11,000. When bonds get revoked, they tend to go up, not down. Do you understand? Anything you want to add?
No.
Or either of you?
I think we've covered it all. She's gonna take the anti-theft class. She's gonna refer her to Max Social Work. She's gonna find a job within the next 30 days, a tax-paying job. And we're gonna extend it for 3 months.
And I will hold up on the dismissal on the theft until we have that 30 days, so we know for sure
Okay.
we've had a good faith effort.
We're not asking much from you. We just want you to be a productive person in this line So the cycle stops. The last year have been just, I mean, really. Do you understand? Can you get it done? Okay, good luck to you. All right,
Thank you, Judge.
so Veronica, we'll give her a PR bond now on the DWI. And then let's amend the conditions, do that, and then we'll see her back in 30 days. She's got to be back here.
Are you gonna file the dismissal for the motion now?
Well, she's got to sign the amended conditions first, so amend it so that she has a job within 30 days, no drugs, no alcohol, no drive. Does she have a license to drive it? Is it eligible?
Do you have is it?
Just because you got a license doesn't mean it's eligible with DPS though.
I paid the fees for the suspension to be lifted, and I paid the fee for the interlock.
Okay, you're on probation for this DWI. If you want to drive, you have to first,
It is
Have-
eligible, Judge.
great. You need car insurance. You cannot drive without car insurance. And then you also need an interlock. Those are the three things that you need. So we need proof of those things. We're not going to take your word for it. So if you want to drive first, you have to get the interlock. Someone has to take you to go get an interlock installed in the car. Then you need car insurance. You can't just drive it to go get an interlock. You're not allowed to drive unless the car has an interlock in it. So if someone has to take you to go get the interlock. You also need insurance in your name. Once you have both of those things and we have proof, at that point, we will let you drive.
Okay.
Sure.
Sure.
Because I have the portable and I paid the fee for the portable for the fact that I have a portable to be added on my license, so do I need to get both?
Once you have the interlock installed in your car and you're maintaining it, then we can take the portable off. You only need one of the devices. Okay?
Okay.
Okay, Mr. Trevor. Good.
Thank you, Judge.
Thank you, Mr. Spence. You are Michael Lawrence.
Yes, sir.
Mr. Lawrence, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay,
Yes, Judge, on May 28, 2026, in Harris County, Texas, at 300 Mills Branch Drive, officers observe a white male with a Pride Plumbing vehicle hanging a Pride Plumbing sign on a utility pole at the intersection. Officer recognized the defendant from a previous investigation. Complainant, a security specialist for Energy, told the officer that poles could be damaged when signs are attached without the consent of the company. Energy sent 2 employees to remove the sign that was 20 feet in the air, and the damages were $500.
so he was hanging a,
A sign on the utility pole, damaging the utility pole.
really? Interesting. Okay, Mr. Lawrence, you have the right to remain silent. It's a good idea to exercise that right. You need a lawyer to represent you, and a lawyer can help you navigate through this, but if you say something now, whatever you say, she's going to sit there, type it up to try to prove your guilt, so it's just not worth it at this time. You'll have the opportunity to fight your case, just now's not that time. Do you understand?
Question. Did you say that someone saw me do this? Seen me do this and then I damaged the pole?
Is that what you said?
Yeah, here's the officer observed the white male.
Correct. An officer saw you doing it.
You know?
Okay. Well, I'm not going to argue with you.
Yeah.
Just now, like I said, now's not the time to do it. There's evidence out there. There's testimony. There may be video. There's all kinds of stuff now and today. So we're going to give you time to hire a lawyer. As it stands now, the only bond condition that I'm going to place on you now is do not put up any more signs while this case is open. Do you understand?
Yes, sir, I can put the sign up.
Okay. Now's not the time. You need a lawyer, so go out there, start interviewing people, and at some point you'll have a lawyer and the lawyer can help you navigate through this. Now's just not the time. The only thing I'm asking you now, do not pick up any new cases. Don't be a danger to my community, and don't put up any more signs like this allegedly damaging other poles. Otherwise, it's just not going to go well. If you violate these conditions, I will revoke your bond and I will put you in jail. Do you understand?
I understand.
Great. So I'm going to have you sign a reset. We will have you take a seat in the jury box. I'm going to have bond conditions created for you to sign. Once you sign them, at that point, you will be free to go. All right?
All right, listen.
All right, Judge, page 12, Huerta.
If you don't mind filing those, please. Just, I guess, no new cases and don't put any signs up damaging property. What was the last?
12, Judge?
This is Ms. Huerta.
Yes.
Ms. Huerta, you're charged with criminal mischief and assault of a family member. You're facing up to, do you speak English, ma'am?
Yes.
You were facing up to a year in jail on the assault. You're facing up to 6 months in jail and or a $2,000 fine on the criminal mischief. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
I'm sorry, give me just a second.
Sure. Take your time. No rush. Yeah.
Want to wing it here.
Yep.
On Monday, July 13th, officer was dispatched to a family disturbance. The officers identified the defendant, Amanda Huerta. She was called, the defendant stated she called her daughter's father. The complainant asking for help watching a child. She said they share an 18-month-old daughter, and complainant's not answering calls. She walked to the garage where he lives on the same property, asked him to help, to which she agreed. Defendant said later, the complainant later entered the mobile home where she lived with their daughter, calling her mother a bitch. She told him to give their daughter back. When he refused, she attempted to forcibly remove their daughter from his arms. The complainant then bit her finger, causing pain. Defendant was observed to have lacerations to her left ring finger, which were red and bleeding. Defendant stated she then put her children in the car and left to a nearby store. And it looks like the criminal mischief case is actually an old case. Do you need probable cause from that one?
It looks like it has been found.
Okay.
Yeah, it looks like it's been found. My only question to you is, she has a prior aggravated assault. She has a prior assault. Now we have another assault and a criminal mischief. Are any of the complaining witnesses have any relation to the older cases? Ms. Huerta, I'm going to find that there's sufficient probable cause to go forward with your case. This is not a revolving door. If you ever miss court again, I'm going to triple, quadruple, quintuple, maybe 10 times the bond amount. You have missed court already 2 to 3 times. Your criminal mischief is nearly 500 days old. To give you a little perspective, we set cases for trial at 180 days. You will get one setting on this case, and after that, you need to decide what you want to do. At your next setting, it will be a trial setting on this case. You understand me? Number one. Number two, you are not to have any contact with any of the complaining witnesses in either of these cases, and you will get a GPS monitor on your ankle so I know where you are at all times. You are not to consume alcohol, illegal drugs, unprescribed controlled medication, and you will be randomly tested. If I find that you use, if I find that you violate these conditions, into jail you go. You understand? The next time, your bonds are now at about, what, $5,500? It's just going to go higher and higher and higher. You understand? Do you have the ability to hire a lawyer? How do you support yourself?
I was doing little crafts and selling them.
So how do you support yourself?
I'm self-employed.
How much money are you making on a monthly basis being self-employed, making crafts?
$100, $50.
When is the last time that you've had a real job, full-time, where you paid taxes?
Been on contract, but I was doing nails. I've been nails
You're not answering my question.
last year.
When, okay, it is now time for you to get a job. The people of Harris County don't get to pay for a lawyer for you, and you get to sit at home and play Xbox all day. Do you understand? And I'm now making that a condition of your bond. You're not to consume alcohol or illegal drugs. And I'm telling you, I'm going to test you like crazy. Do you understand?
Yes, sir.
I'm bringing you back in 2 weeks, and I want to see what you have done to get a job. If you've done nothing, it's just not going to go very well between us.
The judge, it does not appear that any of the prior complainants are the same as this complainant.
Okay. Don't worry about filing conditions since we're going to have her monitored. I'll have Veronica take care of all the conditions. And then is discovery complete on the mischief? Victoria, do you mind appointing her lawyer this morning, please? That way we'll give the lawyer one setting on the mischief and then to figure out what they want to do.
It looks like we have a rift that is outstanding on the mischief. I'll prioritize that now.
Yeah, if you don't mind, we'll give them a full 30-day setting, but after that, this is not a revolving door and I'm going to do everything in my power to protect my community. If I have to put you in at a high bond, no one's going to lose sleep over it. Do you understand me, Ms. Huerta? I'm not asking much from you.
Yes, sir.
I'm going to have you sign a reset and then we will have you take a seat in the jury box and we'll find you a lawyer, ma'am. Come on. Good morning, Mr. Ruiz. Sir, you're charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge, April 27, 2026, officers responded to 8737 East Tex Freeway. The complainant stated that she went to check on the defendant after receiving some concerning text messages. The complainant reported during a verbal argument, defendant used his car keys to intentionally scratch her vehicle across multiple panels, causing approximately $1,200 damage. Officer observed scratches consistent with complainant's count and a broken key on defendant's hearing with the missing piece located in his pocket. When asked, defendant admitted he had keyed the beginning.
Great. Okay. Mr. Ruiz, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to have any contact with this complaining witness in this case. If you violate these conditions, I will revoke your bond and put you in jail. Do you understand? You are not to be in possession of any weapons as well. We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset and we will have you take a seat in the jury box. When you come back here, please have a lawyer. Do you understand? What do you do for a living, Mr. Ruiz? Great. You now had a criminal mischief dismissed not less than a year ago. You have 4 other prior criminal histories. It's now time for you to hire a lawyer. Do you understand? Great. We're going to have bond conditions. Good. If you don't mind filing these bond conditions,
Yes,
please.
Judge, can I let you read something just really quick before we talk about the bond conditions?
Sure.
If you could just read the top line of our. Sorry, I didn't know if there's any bond conditions that might be helpful for that.
You have a suggestion?
I don't, that's why I asked. I'm not sure what would be beneficial. I mean, maybe that's something that Nancy has. Because that's why there's not too big to talk about that.
I guess let's finish your reigns, then we'll talk. I don't know. My only problem also is that he just had a mischief.
I completely agree.
The other thing is that, we give you appointed lawyer after appointed lawyer after appointed lawyer after appointed lawyer after
Oh, no,
appointed
I
lawyer.
need to maintain that.
Yeah,
I think
yeah.
just for us to have that conversation today.
Yeah.
Absolutely.
Is that it?
Yes, Judge, let me give you a case number from council.
Okay,
26227.
sure. Okay.
065.
May I approach you on this?
Are you ready?
Yes, Judge. Good morning. Your Honor.
Hey, good morning. Is your client here?
Yes, yes.
You want to bring him up? I need to give you this cause number. It looked like this is off docket.
Yes, it is, Judge. It's a 2B situation.
Just one moment. The system's super slow today. Okay, I'm ready.
It is 262-7065. Great. Thank you so much. Good job. Rivera, come up. Is he speaking?
He does.
Good morning. How are you? Good to see you.
Good morning, Mr. Rivera.
Good.
Mr. Rivera, you're charged with assault bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
I'm sorry. On June 22nd, 2026, officers responded to 1515 Volcom in regards to an assault. Complainant was working at a crosswalk. When he asked the defendant, a valet driver, to move a patient's car closer, complainant got the keys from the patient and then defendant snatched the keys from the complainant, causing the complainant to become agitated by the defendant's actions. Complainant approached the defendant in an aggressive manner, saying, "Don't snatch anything out of my hands." Defendant stated he thought he and the complainant were about to fight, so he pushed the complainant using both hands, open palm to the chest, causing him to fall to the ground. Complainant advised he felt pain on the bottom of his right foot and wishes to press charges.
Okay. Mr. Rivera, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to have any contact with this complaining witness at all. If you do, if you pick up a new case or endanger my community, it's just not going to go well for you. Do you understand?
Yes, sir.
So it looks like no bond has been set on this case. What do you guys think?
Judge, prior criminal history. Well, how do you look at prior arrests and history?
Looks like this is a third assault.
Yeah, this one.
I see a second assault. It looks like he had oh, I'm sorry, you're right. No. It looks like he had an A from a P and that was dismissed. So this looks like a second.
So from what I found, Your Honor, the only convictions he has is a possession of 102 ounces when he was 18.
Judge, I'd say $2,500 would be appropriate for us.
Judge would ask for $1,000 bond. He's Houston born and raised. Like I said, the only conviction he has is the marijuana. His entire family's here. He's been support, responded. He's gainfully employed. He was employed at the time. It's that job. He's now working at Home Depot on the training program. Legal flight risk now, legal thing to the community. So we got for $1,000.
Are you opposed to a PR bond?
I'll leave that up to the court, Judge.
Okay. So,
I don't think it's particularly egregious as far as
yeah,
that.
Mr. Rivera, I'm going to grant you a PR bond today. I'll set your bond at $2,500, but this isn't a revolving door. You will not get PR bond after PR bond. I'm not asking much. I mean, you watch the news?
Yes.
Yeah, it sucks. I mean, really, the amount of blood that's on our streets it's just disgusting, you know? We're not asking much, just a little patience goes a long way in this life, you know? Really, it's so much can be avoided, so much money is spent on just really. So as a condition of your bond, like I said, don't go back to this place, don't have contact with this person. Bond is set at $2,500. We're going to grant him a PR bond. We will have bond conditions created for you to sign. Do not leave until you sign them. We also have bonding paperwork for you to sign. And I think that's it. So for now, I'm going to have you sign a reset. We will have you take a seat in the jury box, wait for someone to call you up, and then we'll have you sign everything. All right. Thanks for participating. All right. Is this a true first?
True first, he was PPI eligible, Judge, but he works offshore. We had it's gonna be too tough for him.
Okay. All right. Mr. Solis.
He took the smart approach instead of angering the DA's office and the
Well,
court.
smart approach is, I guess, relative, because understand when you plead guilty, it goes on your record. It's going to be there for the rest of your life. This isn't Target. If you don't like it, you can just return it. Once you plead guilty, it's there forever, and this will have consequences on you. I'm telling you now, anything easy in life, when you take a half-assed approach to it, you just get a half-assed result. Same thing with convictions, my friend. This will affect you, whether it's insurance, whether it may be job, whether it may be who knows what the hell, licensing for anything in the future. Are you sure you want to do this? You were giving up the right, well, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you've worked out is 3 days in Harris County Jail to be probated. I'm sorry, with credit for the 1 day that you have done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. If you're on probation or parole, pleading guilty to this offense may result in the revocation of that probation or parole, resulting in further confinement. Is this what you want to do, Mr. Solis? You want to plead guilty to this offense? How do you plead to this offense? Guilty or not guilty? I am going to find you guilty. I will follow the agreement, sentence you to 3 days in jail, give you credit for the 1 day that you've done. I have to suspend your license. I will do it for the minimum, which is 90 days. Do not drive until you get a license. And good luck to you, sir. Thanks.
Surcharges away.
Surcharges, yeah, there are court costs still responsible, but yeah. Okay, cool. Okay. Who's next?
Brianna Treadwell.
Okay,
This is the young lady that, I was appointed to on this past Friday.
Right.
DWI. She picked up a theft
that
case.
case.
And at the time, you seemed inclined to keep her on as long as,
You
she
think?
spent the weekend in jail. I've spoken with the DA. I think we've got something that's viable that we can do. The DA says that if she's extended 3 months, take an anti-theft class, documented job seeking attempts, I'm going to refer her to Max Social Work for any help she might need. Then after the 3-month period, so that would be December, the DWI probation would be over and the DA would be willing to dismiss their theft case.
Can you bring out Ms. Treadwell, please?
I think, and that, yes, Judge, I was fine with whatever level of extension, but I do think her issue seems to be not having employment. And I think that leads to her DWI.
And I agree with you. So I agree with you. So what we will do is we will extend her for 3 months, but we will have her come back in a month. And I want proof that she has an actual 9 to 5 legitimate tax-paying job. And if she doesn't, then it's very possible another motion gets filed. And we will continue to play this game until she gets an actual J.
And I will dismiss the theft now so that she can continue on probation. And if we have any issues, it can always be refiled.
Great. Just let her
And
know.
I'll refer her to Max Social Work today. So I think she's on holdover in Court 8, and so.
Yeah, they're getting.
you-
Manny, you want to talk to me?
Yes, sir. Real quick, Judge.
Hi, how are you?
Real quick, we have a case on Thursday. And I'll give you the class number. Sean is out of town and I'm by myself and I have a case in Brazoria also.
You want to come earlier?
Well,
Is it a DWI?
It is a DWI second. Are you okay if we come Wednesday?
Yeah, of
The
course.
only thing I was gonna ask for, if you let me bump it a week to next week.
Hell no. It's a DWI second, but you can come earlier.
Okay, we come Wednesday.
Or he can come by himself. I won't treat him bad, I promise. I mean, no back rubs or anything, but you know.
Okay, I prefer to come early. I'll come Wednesday if you're.
Okay, or you can come tomorrow, whatever you want.
All right, awesome.
Yeah.
Thank you, Judge.
For sure. A week is just too long without bonking on a second. Mr. Strauss. Hey, good morning.
Good morning, Judge. Thanks for sitting there.
Sure.
I was in town.
Not a problem. Don't worry about it.
Your Honor, today I got Tyler Schmidt on docket. Just got hired on it yesterday at the BDR judge.
Page 23.
I'm told he did do a drug test this morning and it has. He got the drug positions on July 2nd.
Okay.
Did the drug test on July 9th. He did do a drug test this morning.
Oh,
He was living on the street, Judge, he was on the street. He didn't have a home, he now stable. Finally has a job,
he tested positive for meth.
he has a job now. He has a place to live.
I'm gonna test him twice a week. If I'm not taking him in custody now, he's testing every Monday and he's testing every Thursday, so I know he's not using. I'm sorry, it's the only way that I'm gonna do
Too
it.
much work to do once a week,
No, because you could theoretically, the day that you get it, you know it's only once a week, so you get tested on Monday. I'm gonna go get blown Monday night. And then you know it's not coming for who knows how long, you know, so that's why it's twice.
And once you see the continuation of negatives, can I approach you on?
At some point, if we see, but I want more than just, I mean, I want to see proactivity and then, yes, but we don't have a drug patch. We don't have so many resources. It's just, yeah, we used to have a lot of things, but it's,
Sorry, I was just trying to think.
no, I know, no. It's, so that's the only way that I know is to actively, physically test them with, when we have this, I have Mondays and Thursdays, so I know they're not using. Yeah, I mean, I won't take him into custody today, but he's testing Mondays and Thursdays. That's the only way I'll know.
Going whenever.
Yeah, so we'll create the order, so he just goes right in at 7 in the morning and he can, goes in and then he goes out.
Yes, sir.
Yeah. Okay.
Thank you. I think about it.
He can't leave though, because needs to sign amended conditions.
Yes, sir.
Okay. Hi, Ms. Henley. Tell me, how's it going with Mr. Tolliver? How's it going with Mr. Tolliver?
He's not gotten it out yet, he's been flying. And I still don't have any evidence.
Okay.
Okay, I'm gonna set him for another 2 weeks, but he needs to come back here with proof of a ton of applications, and if he doesn't, it's just not to let him know.
Yes, sir.
But I want other than his word.
Yes.
Yeah, okay. All right. Yeah.
How are you? Yeah, good job. The one. Oh, no problem.
Hi, Vic.
Hey, Judge,
What's up, buddy?
are you waiting for the judge? Judge, I've got an off-docket matter. My client was supposed to go on a cruise on Saturday and got arrested at the cruise terminal in Galveston because she has a warrant in 2018 that somebody signed the warrant on in 2018.
Wow.
This woman standing
Looks like I
next
signed the warrant, so it must be a good one.
Touche.
3.
Boy, that's a bummer. You're on the way to get on a cruise ship and you have a warrant.
The other 40 people in their party got kicked off the cruise,
Shut the front
but
door.
their luggage went to the Cayman Islands.
What a kick in the ding ding. Wow. 223, Vic, what was it? 223?
223-7987, Melody Rollins.
Wow. Not only did you not go on the cruise. Oh my God. For that. Oh my.
Left my check at. Should be here first.
Whoa.
I'm sure her BTI dot's already loaded, so.
It's not her, it's Elizabeth.
Oh, okay.
Anyway, she's in the Galveston County Jail, and she's being held at no bond.
It's like my cousin Vinny. What more can you add on this? Wow.
I'm not laughing at her expense. I'm laughing at the.
It's really incredible. But Vic, how on earth would they kick the other people off?
They said, you're not welcome to join us. You guys, husband, kids, grandparents, in-laws, get the heck out of here. And they don't even get their money back.
Wow.
That's weird.
Because the wife had an 8-year-old warrant for something that she didn't actually do.
I mean, look, I'm not gonna argue the merits of the case right here.
I'm not asking you to.
I am gonna say though.
I
everything on the
just,
check matches her.
I really, but nevertheless, I find it incredible that they wouldn't.
And the husband told me they traveled internationally, never had any issues coming in and out of Houston, going to Europe,
That's
no
bizarre.
issues. But.
Do you want me to set you a bond? But, but I can set you a bond here,
Yes.
and then, that'll lift the, okay.
Yes.
Bernadette, what do you think?
Yeah, I mean, I think that's the only.
Give me
solution.
a number though. What?
$1,000.
Oh,
Oh, I was gonna set it for $100.
I was gonna say,
But-
yeah, I think that's fine.
$100 is fine.
And then I'm sure that there's probably an offer on the case now as it is.
I don't know if there's actually already an offer in there, but usually they have the PTI stuff already uploaded. But it's 8 years old, so maybe they don't. I'll ask them to upload that and stuff on there.
Can I give you guys get the case number? So if you don't mind setting it,
I still have this in black hair on. I've been here 8 years ago.
yeah, on Roberts.
I mean, I sure still wait a lot less.
Okay.
I forgot wrong.
I wait a lot.
$100.
You did.
Okay. Huh?
Yeah, I'll just leave it.
Yeah, I can't give a PR bond. She's not here.
Right.
So I'll just have to set it for $100 surety bond.
Okay, thanks, Judge.
Yeah, I mean, I guess just go work the bond and then it'll get her out and then just, have you followed an attorney of record?
I just did.
Great.
paperwork.
Okay. All right.
I
Well,
was chastised for my-
that sucks, man. Really.
Yeah.
I feel for her. That's, well, and everybody, especially for the kids, man. Jeez, Louise. That's,
Thanks, Judge.
all right. Thanks, man.
See you, Bernadette.
Bye.
Oh, can you attach this to me?
You're so difficult.
I know.
You're so difficult.
Ready to
Oh,
attach?
you're already attached.
One.
I knew you were-
Is she bond denied because of this?
Yes.
By the way, the signature letter are my signature check. Because I filed that warrant, but just tell me.
Your name is on it. I saw
I know
it.
it is.
I saw it.
No doubt. I have no doubt.
And hey, I wasn't laughing at your client. I can't believe how they would restrict everybody else. That's just, it's just so incredible that
So DWI. Okay.
You're not talking to me, are you?
No.
Okay, fine.
We moved on.
okay, all right, bye then. Good to see you, man.
Bye, y'all. Thank you.
Okay.
You said about
What?
I'm ready when you are. Are you ready? No?
State,
Okay.
I just wanted confirmation on bond conditions for Mr. Smith, Derek Smith. He's, we were both here last Friday. He picked up the POM while on.
Yeah, just don't use, that's it.
Okay.
That's it. Don't use, we'll test them in 50 days. Yeah.
Do you want that mirrored on both?
Yeah, yeah. Okay.
Okay.
Cox, come up. All right, I need you to fill out an application for court-appointed lawyer, and we'll go from there. I understand that you're under house arrest at this time. Is that right?
Okay, just remove me from house arrest.
Which bond condition?
What's my wife condition?
Which bond condition? You said they released something last. So are you working at this time?
Oh, I lost my job. I've been searching for it.
What were you doing before this?
I'm looking at an intro card verification.
Okay, I need you to fill out an application for me. I need to know everything about you to see whether you qualify, what kind of money you have in the bank, who you live with, what kind of household income you have, and I'll take a look to see whether you qualify.
Right now,
As a-
it's my place to live as well. I live in mine.
Okay. Mr. Cox, let me just
All right. Okay, fine.
be frank. I'm going to do everything in my power to protect my city. You're charged with harassment, you're charged with possession of marijuana and a felony threat to disclose intimate visual material. You endanger my community, it's just not going to go well for you. You were ordered not to consume alcohol or illegal drugs. I will randomly test you, and I'm telling you, I'm going to test you within 50 days. If you test positive, it's just not going to go well between us. Do you understand me? When you're out there, know who you're with. Don't hang with the wrong people. I don't care what's going on. You test positive for illegal drugs, including marijuana. It's not going to go well between us. Do you understand me? You will be expected to get full-time employment while you're on bond for this case. So, Veronica, this is Mr. Cox. Test 50 days from today, please. All right, so deputy will give you an application. I need you to fill it out and then we'll take a look at it. All right, please do not leave until you sign the bond conditions.
You're looking at it.
Okay,
Your Honor, my approach.
Yeah.
We have today agreed on the docket. Remember last week, we set it today for the speedy trial violation hearing. I'm being told now that we don't have any prosecutors to have this hearing. We also, I will note that I spoke to, my office spoke to the pretrial people and her brother. Nobody's been able to use this vehicle because it's popping high blows for everybody that tries to blow it. The company for the device has told us that it's just something wrong with the device, which is why she took it and got it calibrated. She's in custody. This is a year-old case that the state took 8 months to file on a very simple DWI. There's a ton of issues. I think this goes further to her rights being violated and not being able to get to a trial and not being prosecuted. I mean, this is just, I mean, we sat here.
Bernadette, what do you say?
Yeah, I don't see a speedy trial issue, Judge, but the case did happen in July of 2025. It was not filed until March. And that alone doesn't make it a speedy trial issue. We have a 2-year statute of limitations to file a case. He's raised some issues about some evidence not being in. I don't know the status of that. It does look like we got a lot of things in late June and early July, so it does appear that things have come in. We've got medical records. In fact, there's some things that can be released that I'm doing now.
And Your Honor,
How old is the case since the time it's been on the docket?